Hello everyone, my name is Cristobal Garcia. I am a student in the College of Professional Studies at Northeastern University. This is a presentation that will address the issue of how qualified undocumented students residing in the United States have difficulty accessing higher education institutions. Hence the title of my signature assignment, Undocumented Students and the Accessibility of Higher Education. This presentation was created for the course EDU 6203, Education, Law, Policy, and Finance, as part of the signature assignment created to demonstrate an understanding of a higher education legal issue and the implications the issue has on campus-based administrative decisions. In recent years, we have seen a rise in the number of undocumented students that have been enrolled since they were children in public schools. Some of these children live the majority of their lives in the United States, recognizing it as their only home. Of this demographic of students, those that are able to navigate through the K through 12 system find an additional obstacle created by their lack of citizenship. Being undocumented leaves them ineligible for in-state tuition, being that one of the requirements for this prize is to be legal residents of the state. Aside from being denied the in-state tuition price, these students also do not qualify for financial aid, since grants, loans, and several scholarships require the submission of a Social Security number. There is a large number of students that have followed the rules of the American education system for the majority of their lives and have the academic aptitude to qualify for admission into a higher learning institution, but due to their citizenship status have a barrier to their success. This issue is recognized by every governing entity that ranges from individual states to the federal administration. One of the first questions to come from this issue is who is responsible for coming up with a solution? When it comes to education in accordance to the Constitution, since it is not one of the explicitly stated responsibilities of the federal government, it is given to the states to manage. Another concern raised by this issue is whether passing any legislation that supports non-citizens runs in contradiction with any established government laws, and what are the possible ramifications that can occur in regards to how issues of immigration and amnesty are handled. However, though this might seem like a new problem, this is not the first time that the issue of undocumented students and education has received the spotlight. With the influx of students from foreign countries, they are a large enough part of the population that they cannot be ignored. Over the last half-century, the demographic of undocumented students drew attention as a group in need of support. Depending on the state, there were multiple answers as to what could be done, but the main concern was that debate gridlock could lead to inaction, which could potentially leave these students to become a hindrance to the nation, increasing the number of uneducated residents. In 1975, the state of Texas declared that foreign-born children could be denied access to public schools, to which several families filed a class action lawsuit against the policy. This became known as the historic landmark case of Plyler versus Doe, which ruled that education was a right to every student regardless of citizenship status. The opinion behind the decision noted that undocumented students were already at a disadvantage economically, linguistically, and had to contend with many racial prejudices, and that denying them an education would only make it difficult for them to be successful, should they one day become citizens. The decision in Plyler versus Doe was supported by the 14th Amendment of the Constitution that reads, "No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The key word in this text being person, meaning that citizenship was not a requirement for students to have a right to life, liberty, or property. While a public K-12 education was perceived as a right, this case did not cover the base of higher education. This brings us to the present, where students of similar background benefit from the opportunity of a public education, but are not able to continue their academic aspirations without the aid of new legislation that covers the basis of higher education. Some states have enacted legislation to try to resolve the issue, but the topic is still highly debated in terms of affordability and the role of who has the responsibility to solve the issue. There are currently 18 states that have some kind of legislation in place to try to address the issue of affordability by trying to at least allow undocumented students to be charged in-state tuition for their home state. The legislation at these states bear some common threads and are setting precedent as to what action can be taken to address the issue of accessibility to higher education for undocumented students. In California, for example, Assembly Bill 540 ruled that a student that attended high school in California for 3 or more years, graduated from that same high school, and later enrolled at an accredited institution of higher education in that same state is exempt from paying non-resident tuition, meaning even though they don't have a citizenship status, they are still able to at least pay the regular tuition price of a student that is a resident of the state of California. This being a fresh bill received some criticisms, which were expressed in the case of Martinez versus the Regents of the University of California. In this case, the plaintiff argued that students with the proper citizenship status were being denied the benefits allotted by the policies of the Assembly Bill 540. AB 540 stated that meeting the aforementioned criteria permitted students with non-resident status to be charged in-state tuition for higher education institutions. The plaintiff claimed that the Assembly Bill had unjustly denied students with a proper citizenship status the in-state tuition cost, which would be considered breaking the 14th Amendment right of those students, and had shown favoritism towards undocumented students. The truth of the matter for many state bills like the one in California lies in their interpretation of the term persons in the 14th Amendment. Person has a universal application that extends beyond citizenship. For this reason, in the case of Martinez versus the Regents of University of California, the court ruled against the plaintiff because AB 540 stated that any person is eligible for the benefit of in-state tuition so long as they meet the three criteria for eligibility, which meant that not only did undocumented students benefit from this decision, so did students born within the United States but had only been in California for a few years. What this case also proved was that the support that undocumented students need relies on intervention at the federal level. Though states like California are lowering the cost of their tuition, access to financial aid is still limited to students with proper citizen status. While California continues to make modifications to legislation that affects tuition cost and in-state financial aid, this still does not solve the problem at a national level. This is not to say that there has not been an effort to address this issue. In 2009, the Development Relief and Education for Alien Minors Act, or DREAM Act, was being pushed through the Senate to provide an opportunity for students that graduate from high school with an undocumented status to pursue higher education and achieve their full potential. The bill itself, if passed, offered a path for students that are undocumented to achieve a permanent residency. In regards to higher education, this bill offered the promise that graduating from high school, undocumented students had the opportunity to become more productive members of society. Arguments against the bill are that this legislation opens the possibility of a wider form of amnesty that could encourage more immigration through informal avenues on the promise of earning a quick citizenship. Former President Barack Obama was a proponent of the legislation DREAM Act that, if enacted, would have eased the issues of residency and higher education access for students that were brought to the United States as children. Passing the DREAM Act would allow students to continue their education through college, join the military, find meaningful employment, and become high contributors to taxes, thus bringing in more revenue to the country. At the national level, this demographic could potentially be a great asset financially, and help avoid the issue that, if otherwise not supported, are added to the statistic of disenfranchised youth that continue the cycle of poverty in communities that are already of low socioeconomic status. The bill is still undergoing review, but the future of its passing is dependent on the actions taken under the current federal administration. The issue of how to solve the accessibility crisis for undocumented students in higher education is a continuing process. The intersecting issues of immigration reform, affordability, tuition cost, and ambiguity of who should be responsible in solving the overarching issue present a challenge to any government entity trying to address the topic. Landmark cases at the state level at this time are serving as models as to what can be an effective practice to addressing the issue and what challenges can come with enacting them. While it is commendable that individual states are trying to provide solutions, this is an issue that is prevalent across state lines, and for that reason, the main stage that can provide a clear answer will likely be at the federal level of government through new legislation. On that note, thank you for following my signature assignment presentation. For more information about this issue, click on the link in the description to view the full written document.